Welcome back to the Global Business Channel. Thank you for joining us once more for our 39th video. Today we'll be discussing the role of a secretary for companies and legal entities. The 10 items this video will be covering regarding secretaries include corporate governance and compliance, board administration, liaison between the board and shareholders, advisory role, statutory obligations, record keeping, corporate changes and transactions, ethical standards and corporate culture, training and development, and special responsibilities. Finally, we'll review some of the key provisions regarding secretaries under the Mauritius Financial Services Act 2007 and the Mauritius Companies Act 2001, as that is the country in which I operate and work. We publish weekly videos on topics related to offshore global business, corporate, financial, and compliance sectors. We encourage you to subscribe to the channel and give this video a thumbs up if these topics are of interest to you. Lastly, for ease of reference, all videos are arranged in playlists which we have created on various subject matters, so feel free to browse through them. Without further delay, let's get started with today's video. The role of a secretary is vital to the smooth functioning of a corporate entity. A secretary is a senior position within a company or organization, often regarded as the primary point of communication between the board of directors, its shareholders or legal owners, and plays a crucial role in ensuring that the organization complies with legal and regulatory requirements. Whilst this video will reference secretaries concerning private and public companies, it is important to note that in most jurisdictions, a secretary may be appointed to serve this role on non-company entities, such as limited partnerships, general partnerships, foundations, and societés, to name a few. Here's a detailed breakdown of the responsibilities and functions of a company secretary. Number 1, corporate governance and compliance. Ensuring compliance. The secretary ensures that the company adheres to legal obligations, including corporate laws, regulations, and governance standards. This involves keeping abreast of changes in laws and regulations that affect the company's operations and ensuring that the board and the company's policies align with these laws. Governance practices. They promote best practices in corporate governance, which involves advising the board on governance issues and implementing policies that support effective board operations. Number 2, board administration, meeting coordination. The secretary is responsible for organizing and coordinating board meetings and shareholder meetings. This includes preparing and distributing agendas, ensuring that the board receives the necessary information before meetings, and recording the minutes of proceedings during said meetings. Relating to this, minutes of proceedings and documentation. Maintaining accurate records of board meetings, including minutes of proceedings and written resolutions, is a key responsibility. The secretary ensures that these records are properly documented and securely stored, often serving as the official custodian of the company's records. Number 3, liaison between the board and stakeholders. Communication hub. The secretary acts as the central point of communication between the board, senior management, and shareholders. This also includes managing communication with regulatory bodies, government agencies, and other stakeholders. In talking about regulatory bodies for Mauritius, this would include, for example, the Financial Services Commission and the Registrar of Companies. Shareholder relations. They manage the relationship between the company and its shareholders, including handling shareholder communications, organizing annual general meetings, otherwise known as AGMs, and ensuring that shareholders receive timely and accurate information about the company's performance and governance. Number 4, advisory role. Legal and strategic advice. The company secretary often provides legal advice to the board and management, particularly concerning company law, corporate governance, and regulatory compliance. They play a strategic role in advising the board on potential risks and the implications of their decisions. Risk management. They assist in identifying and managing risks related to corporate governance and compliance. This includes ensuring that the company has a robust risk management policy or policies and procedures in place. Number 5, statutory obligations, filing and reporting. The company secretary is responsible for filing statutory returns and ensuring compliance with legal and regulatory requirements. This includes submitting annual returns, financial statements, and other necessary documents to relevant authorities, such as we mentioned for Mauritius, the Registrar of Companies, or the Financial Services Commission. Maintaining registers. They maintain statutory registers such as the Register of Members or Shareholders, Directors, Chargers, Officers, and Secretaries, and ensure that these registers are up to date and accessible as may be required by law. Number 6, record keeping, document management. The secretary ensures that the company's legal documents, including its constitution or in other jurisdictions, memorandum and articles of association, share certificates, and any related contracts, are accurately maintained and updated. This also includes safekeeping of the company seal, where applicable, and ensuring that documents are executed properly. Confidentiality. They are responsible for maintaining the confidentiality of sensitive company information and ensuring that confidential documents are securely stored. Number 7, corporate changes and transactions, corporate restructuring. Any event of corporate restructuring, such as mergers, acquisitions, or demergers, the company secretary plays a critical role in ensuring that all legal procedures are followed and that the company complies with the relevant regulations. Issuance of shares. They manage the issuance of shares, including the preparation of documentation for share allotments, transfers, and dividends, not to exclude all the statutory filings with the authorities or regulatory bodies. Number 8, ethical standards and corporate culture, promoting ethical conduct. The company secretary promotes ethical conduct within the company or organization, ensuring that the board and senior management uphold high standards of integrity and transparency in their operations. Corporate culture. They contribute to fostering a positive corporate culture by promoting diversity, equity, and inclusion, and by supporting corporate social responsibility initiatives, otherwise known as CSR. Number 9, training and development, board development. The company secretary is often involved in the training and development of board members, particularly in areas related to governance, compliance, and fiduciary responsibilities. Induction programs. They organize induction programs for new directors, ensuring they understand their roles and responsibilities and are familiar with the company's operations and governance framework. Number 10, special responsibilities, crisis management. During crises such as legal disputes, regulatory investigations, or corporate scandals, the secretary plays a crucial role in managing the company's response, ensuring that communication is handled appropriately and that legal obligations are met. And finally, data protection and privacy. With the increasing focus on data protection, the company secretary may also oversee the company's compliance with data protection laws, such as the General Data Protection Regulation in the EU, or in Mauritius, the Data Protection Act of 2017, ensuring that personal data is handled in accordance with legal requirements. The role of a company secretary is multifaceted and essential to the governance and legal compliance of a company or organization. They serve as the backbone of corporate governance, ensuring that the organization operates within the bounds of the law, that the board functions effectively, and that shareholders are kept informed. The company secretary is not just a record keeper, but a key advisor to the board and management, contributing to the overall strategy and success of the organization. Let's now take a moment to go through the major provisions of the Mauritius Companies Act 2001 regarding secretaries, as well as the Financial Services Act 2007. We will be summarizing the relevant sections, but do take a moment to pause the video to read through them if you are interested in such. Section 94 concerns the Secretary's duty to supervise and maintain companies' share registers. It mandates that a company secretary must ensure the proper maintenance of the share registers and that share transfers are promptly recorded as per Section 88. Failure to comply with this duty constitutes an offense punishable by a fine of up to 200,000 Mauritian rupees upon conviction, which amounts to about 4,300 US dollars or 3,900 euros. Section 163 concerns the appointment of company secretaries. Subsection 1 states that every company, except small private companies, which, according to sections 2 and 209 of the Act, are those which have had a turnover in their last accounting period of less than 100 million Mauritian rupees, or 2.17 million US dollars, or 1.95 million euros, or those offshore companies incorporated as authorized companies, must have at least one secretary. The said secretary must be a natural person of legal age and capacity and must ordinarily reside in Mauritius, as stipulated in Section 164. Subsection 2 stipulates that a person cannot be appointed as a company secretary unless they have, in an approved form, A, consented to the role, and B, certified that they possess the qualifications specified under Section 165. This information is usually filed on the Mauritius Corporate Business Registration and Integrated System of the Mauritius Registrar of Companies. Subsection 3 asserts that a person named as the secretary in a company's incorporation application or in an amalgamation proposal assumes the role from the date of incorporation or when the amalgamation becomes effective, continuing until they leave the position in accordance with the Act or the company's constitution. Subsection 4 argues that the board, subject to the company's constitution, may appoint or remove the company secretary. Subsection 5 mandates that the position of secretary must not remain vacant for more than 3 months at any time. Subsection 6 in turn states if the directors fail to appoint a secretary within the 3-month period, the registrar or the Mauritius court, upon application by a shareholder or a director, may order the company or its directors to make an appointment. Subsection 7 asserts that if the company or its directors knowingly fail to appoint a secretary within 2 months after being ordered to do so by the registrar or the Mauritius court, they commit an offense punishable by a fine not exceeding 100,000 Mauritian rupees upon conviction, which is equivalent to about 2,170 US dollars or 1,950 euros. Section 164 regarding the Registrar of Companies having the authority and powers to approve firms or corporations as appointed secretaries states in subsection 1 that the Registrar of Companies may approve the appointment of a firm or corporation as a secretary if the following conditions are met. A. At least one member of the firm or one director of the corporation must ordinarily reside in Mauritius, Residing or resident has the same meaning as the Mauritius Income Tax Act 1995, stating that taxes must be paid in Mauritius. However, the 13th schedule of the Act stipulates that this section shall not apply to offshore companies holding a global business license or approved as authorized companies by the Financial Services Commission of Mauritius. B. The members of the firm or the director of the corporation who assumes responsibility for the firm or corporation's work as a secretary must be qualified under Section 165. C. The registrar must be satisfied that the firm or corporation is fit and proper to be appointed as a company secretary. Subsection 2 stipulates that the registrar can approve the firm or corporation for appointment as a secretary under A, specifically for a named company, or B, generally as a company secretary, allowing the firm or corporation to accept appointments as a secretary for companies without further approval. Subsection 3 declares that the registrar may revoke an approval given under subsection 2, but must first give the firm or corporation an opportunity to present their case through representation. Subsection 3a asserts that subsections 1 to 3 do not apply to a corporation that is a foundation registered under the Mauritius Foundations Act 2002. And subsection 4 discloses that any firm approved by the registrar for the purpose must promptly inform the registrar of the names of all partners in the firm and notify any changes. Section 165 regarding the qualifications of company secretaries states in subsection 1 that every secretary of a public company or a private company, except for a small private company or an offshore authorized company, must be one of the following: A law practitioner, legal consultant, law firm, a member of one of the bodies mentioned in section 198.1, otherwise known as qualifications of auditor, a member of the Institute of Chartered Secretaries and Administrators of the United Kingdom, or a member of the Chartered Institute of Management Accountants of the United Kingdom. B, a member of a professional association of company secretaries approved by the minister under section 111.2 of the former and repealed Companies Act 1984, or by the minister under subsection 2. Subsection 2 stipulates that for the purposes of subsection 1b, the minister may approve an association of company secretaries and publish this approval in the Mauritius Government Gazette. Subsection 3 asserts that the minister may revoke an approval granted under subsection 2 or any approval previously given by the minister under the former Companies Act 1984 if it is determined that the said association is not maintaining adequate standards for admitting its members or is failing to effectively supervise and discipline its members. Lastly, subsection 4 argues that before revoking the approval of any association that has been approved under subsection 2, the minister must provide that association with an opportunity to present its case through representation. Section 166 regarding the duties of company secretaries states in subsection 1 that the responsibilities of a company secretary shall include but not be limited to A, providing the board of directors with guidance on its duties, responsibilities, and powers, B, informing the board about all legislation relevant to or affecting shareholders and directors' meetings, reporting at these meetings, and ensuring the company complies with legal requirements, including the filing of necessary documents. C, ensuring that minutes of proceedings of all meetings of shareholders or directors are accurately recorded according to paragraph 8 of the 5th schedule of the Act, and that all statutory registers are properly maintained. D, certifying in the company's annual financial statements that all required returns have been filed with the Registrar of Companies as mandated by this Act, and E, ensuring that the copy of the company's annual financial statements and, if applicable, the annual report is sent to every person entitled to receive them in accordance with Sections 219, sending annual reports to shareholders, and 220, sending of financial statements to shareholders who elect not to receive an annual report of the Act. Section 167, regarding notice to be given of removal or resignation of company secretaries, states in subsection 1 that if the company secretary resigns or is removed during an accounting period, the company must notify the registrar within 28 days of the resignation or removal. Subsection 2 stipulates that if the secretary is removed, they may request that the company include a statement not exceeding a reasonable length in the annual financial statements for that accounting period, explaining the circumstances leading to their removal. Subsection 3 asserts that if the secretary intends to exercise this right, they must give written notice to the company by the end of the accounting period in which the removal occurred, including the statement mentioned in subsection 2. Subsection 4 mandates that the secretary's statement referred in subsection 2 must be included in the annual report. If no annual report is required, it should be included under a separate heading in a company's annual financial statements. And lastly, subsection 5 states that if the company or any other party believes that the secretary's statement is being used to unfairly publicize defamatory content, they may apply to the Mauritian court. If the court agrees, it may order that the statement does not need to be included in the annual report or financial statements, does not need to be provided to shareholders, or read at meetings. The court may also order the secretary to cover all or part of the application costs. Section 167A concerns company services providers such as management companies who act as secretaries to global business corporations holding global business licenses issued by the Financial Services Commission of Mauritius. Subsection 1 states that no one shall offer the following services as a business unless they are registered with the registrar as a company service provider. A. Acting as a formation agent to help others incorporate, register, or set up a company, foundation, limited liability partnership, or other prescribed entity. B. Acting or arranging for someone else to act as a director, secretary, partner, or in a similar role for a legal entity such as a company, foundation, limited liability partnership, or other prescribed entity. C. Providing a registered office, business address, accommodation address, correspondence address, or administrative address for a legal entity such as a company, foundation, limited liability partnership, or other prescribed entity. And D. Acting or arranging for someone else to act as a nominee shareholder on behalf of another person. Subsection 2 stipulates that the registrar may register a person as a company service provider if A. The person is ordinarily resident or has a place of business in Mauritius, and B. The registrar is satisfied that the person is fit and proper to be a company service provider. Subsection 3 stipulates that the registrar shall not deregister a person as a company service provider without first allowing them to present their case through representation. Subsection 4 mandates that every company service provider must promptly inform the registrar of any changes in its status. Subsection 5 states that a company referred to in Section 164 and a holder of a management license issued under Section 77 of the Mauritius Financial Services Act 2007 who offers any of the services specified in subsection 1 as a business is not required to register under this section. Section 6 stipulates that every company service provider must A. comply with any directions given by the registrar, and B. as soon as possible, but no later than 5 working days after becoming aware of a transaction that may be suspicious, 1. file a suspicious transaction report with the Mauritius Financial Intelligence Unit, and 2. follow any guidelines issued by the FIU. And lastly, subsection 7 avers that a company service provider may, with the authorization from the company it represents, provide the information specified in section 196, company records, to a competent authority under that section. That's it for today's video regarding the role and functions of corporate secretaries. Our next video will cover certificate of incumbencies, which we encourage you to watch, obviously. Thank you for sticking around until the end. Your support means a lot to us, and we hope you found the information, insights, and key points valuable. We'll continue to share informative content, so do not hesitate to return to the Global Business channel for insightful videos on the offshore, global, compliance, and financial services sectors. Take care, stay safe, and we'll catch you in the next one. Cheers, guys.